Mr. Speaker.
Honourable Annette King.
Mr. Speaker, this bill had a very, very poor start on its journey in this House. In fact, the Minister was in such a hurry to make her name and have her photo in the paper that she brought this bill in half an hour before Parliament was to sit at 1:30 in the afternoon. Nobody, including the public or other political parties, had an opportunity to look at it before she rushed it through under urgency to a select committee. So it had a pretty poor start. It wasn't because the bill wasn't ready. In fact, the bill was ready 2 days before she tabled the bill half an hour before the Parliament sat. And half an hour before the Parliament sat, Mr Macleay says is long enough. Well, it might be for him, but the people of New Zealand and the other political parties in this House deserve to have seen that bill when it was ready to be seen. And the member sitting across saying we had 9 years. Well, of course, the changes that she's making in terms of the length of sentences were in the bill we introduced, plus changes for children in New Zealand, all of it dumped for this hastily drawn together bill. It has become clear that this bill is more about hype than it is about substance. It's about slogans and not about good policy. It's about political expediency and not about sound decisions based on evidence. And if you wanted proof of that, Mr Speaker, you only needed to have sat and listened to the submissions at the Select Committee. Her bill is not based on sound evidence, and that was told to us over and over again as we questioned those submitters. I also think it was a shame that the Minister tried to pull the wool over the eyes of this Parliament and the public when the bill was introduced. She told this House that her flagship boot camps would not be implemented till the end of 2010. The bill was not even finished in the Select Committee before she set up a pilot of boot camps at Burnham. We hadn't even finished the bill that was going to be the most important part of this bill, to make boot camps part of the options, before she went ahead and started to implement it. And now she has once again told us what a great thing this is, based on a few months of a pilot, without proper evaluation, without proper research. And it's that sort of sloppy thinking that really has tarnished this bill that the Minister has brought in. It's a lightweight bill, and it received very little support at the Select Committee. It received very little support for the main parts of it, particularly around the age, of lowering the age that children would go into the youth courts. There was almost overwhelming opposition to boot camps, and where there was some agreement was around the extension of the range of sentencing options. And we support an extension to sentencing options. However, we also are rather worried about how effective compulsory mentoring would be. We haven't got any evidence that making people have a mentor is necessarily effective. We also don't think it addresses the fact that 80% of young people who appear in the youth court now are under the influence of alcohol and drugs. And the Minister is saying that, well, they'll be able to get some help with alcohol and drugs. We have not seen where the resources, the training and the services are going to be provided, so those young people who do have those problems will receive those services. It has not been shown to the Select Committee when we asked for it. It has not been shown to the public of New Zealand or the submitters. It's hot air. That's what we have had from the Minister. The submissions on the bill were overwhelmingly opposed to lowering the age in which children could appear in the youth court. And I think it is quite significant what Judge Beecroft, the judge of the youth court, had to say. After all, Minister Bennett has paraded Judge Beecroft round as the pin-up boy for her policies before the election. So therefore she ought to take some notice of what he said when she brings in a piece of legislation. He said that he believed this was constituting the most fundamental change to the system since its inception in 1989. Judge Beecroft also highlighted, saying there is a real concern by youth court judges that the court will be assuming responsibility for the worst child offenders who by definition will have the most serious care and protection issues, yet the youth court will not have the necessary statutory ammunition to deal with the inevitable care and protection issues which are at the root of offending. So when the Minister talks about this bill, she talks about making sure they get the appropriate punishment. But she doesn't talk about the root of their offending, dealing with their care and protection issues. Labor raised in the Select Committee, if the concern is that the family court doesn't have the tools, why not give a greater range of powers to the family court rather than transferring it to the youth court? But we couldn't even consider that, Mr. Speaker. We were told it was outside the scope of the bill. It did not need to be outside of the scope of the bill. The Minister wrote the bill. She could have said, yes, why don't you look at it? And now she's saying, won't the Select Committee inquiry be good? Looking at a youth offending and the range of tools that the family court might have. Why close the door after the horse has bolted? Why not do it first? Why not have looked at those before bringing in this bill? And Judge Beecroft has made it clear that this bill does not deal with those issues that address care and protection. And the right approach would have been to look at extending the powers within the family court. The other major issue, which I think every submitter, well most submitters, did submit on, and that was the issue of military-style camps. John Key, before the election campaign, did call them boot camps. Unfortunately, either because people had forgotten at the Select Committee from the National Party or they didn't agree with it, they believed that calling them boot camps was a misnomer. But that is what the Prime Minister called them in the run-up to the election. He did it for a purpose. He did it for political expediency. That is what they were called, and that is what every submitter who came to the Select Committee called them, boot camps. They then we set about pulling apart the reason why New Zealand ought not go down that path. That we did not need to have military-style camps set up in New Zealand in the style of a boot camp. They pointed out the failures overseas. They pointed out the failure within New Zealand when we had that sort of approach and the recidivism that came with it. And they pointed out that there were other approaches. It also was pointed out and quite clear to us, you didn't even need to include this in a bill to be able to have military-style camps. Because, we've got one set up at Burnham without this legislation. So if the government wanted to put in place military-style camps, we didn't need to go through the expense and the time of calling submitters from all around New Zealand for them to tell us they think it's a bad move. If the government really wanted to do something in terms of the most serious offenders, and after all we did hear from the police, we're talking about 80 apprehensions, not 80 offenders, not 80 arrests, but 80 apprehensions, and some of those are children who've been apprehended more than once. So we're talking about a very small group. Why not, Minister, keep open Te Herehanga? Why not put your resources into that program that has shown a huge success? But for political purposes, you've decided to close Te Herehanga. You've decided to close it, even though it is showing that it is working. And Mr. Speaker, what is so sad about this is the shonky figures that the ministers use to justify closing it. They tried to put the entire cost of establishing one program on 8 kids. And as somebody said, why not put the entire cost of Wellington's maternity hospital on the first birth that came out of it?